single bench, Lordship.
Let us see. 7 years and above, no? Mr. Joshua?
Lordship, generally the criminal appeal is filed before the division bench. So
No.
apparently my learned friend has made a submission which I have to cross-check, Lordship. My apologies, Lordship. If Chapter 2,
Verse 7. Sorry, Rule 7.
Rule 7.
You are very familiar with Bible. Chapter 2, verse 7. Division bench for hearing of cases of evidence of any consequences of 2 or more. On whether a severe sentence of life has been awarded to be heard by whether the single inmate they have the inmate has whether they may refer the particular patient. Chapter 2,
Rule 7, that's what my learned
Rule
friend is
7.
saying. Yes, Lordship.
a division bench. Your submission is not to be listed before a division bench. It should be 7 years and above. Is that your case?
10.
10 years and above.
Yes.
So chapter 7 does not say that. Rule 7 does not say that.
Lordship, it appears the punishment below 10 years have to be filed before have to be listed before the learned single bench.
That's why. Where is that
Yes,
provision?
Lordship. I'm not aware,
Let
but
us be sure.
I can have a look, Lordship. Are you sure about it?
We will list it next week again.
Lordship.
You kindly have a look and then
Lordship.
apprise this court.
My Lord.
Okay.
In that case, Lordship.
Okay.
My Lord.
List it again on.
When is next Wednesday?
When is next Wednesday? 19th.
19, Lordship.
Listed again on 19th for 2023.
Bless you, Lordships.
You just go through and kindly apprise the court of that.
My Lord. Lordships.
Item 2, IS Civil 31, 2023.
Mr. Lordship,
Yes.
the present I filed for the condonation of delay of 96 days, Your Lordship, in filing the review petition.
Review is against, review is for the judgment
Order
dated 2/11/2022,
Yes, Lordship.
where my Lord Justice Soto and me, we have actually delivered the judgment.
Yes,
Now, my Lord Justice Soto is no more there. Will it be possible, will it be permissible for me to actually take up this petition, or whether it has to be referred to the Honorable Chief Justice?
Your Lordship, for that matter, I'll leave to the court, Your Lordship.
No, not leave to the court. Because
But then, since you were also, Your Honorable Lordship also.
that is there, because actually, even in Gauhati, in some similar cases,
Yes, Lordship.
where me and the Honorable Chief Justice sat for a division bench,
Yes, Lordship.
and where we passed some order, after the Honorable Chief Justice retired, the matter came up for review. So actually, it was referred to the Chief Justice. And only thereafter, the present Honorable Chief Justice and myself, we took up that review.
Yes, Lordship.
Yes, kindly call this, whoever is in charge of this. whether we need some information on this. Okay, revised list after some time, okay?
Yes, Lordship.
Item 3, IS Civil 39, 2023.
Yes, Mr. Paul.
Your Lordship, my learned friend has filed one IEA, and I was out of session. I have received only today,
Okay.
and I require some instruction from my client in that regard. So 1 week time may be given, Your Lordship. And furthermore, Your Lordship, this RFA is 2011 matter, and till now this case record has not been reached, lower court record. So
Has it been called for?
because the matter was dismissed twice, then it was restored twice. So if the record is not called for, then lower court record may be kindly called for and matter may be disposed finally. And this is not a large matter also.
Whether we have received this, no, right? What is the order? So in IEA,
39.
which is the relevant IEA for today?
There are two IAs, Your Lordship.
Two IEAs. One is for
30 and one is 39.
So we are on 39.
39. So
Okay.
actually, Your Lordship, my contention is that I am the landlord.
No, that of course we will take up when we.
And I require some instruction in that regard, Your Lordship.
So this is IEA 39.
39.
So we're listed on 19th. Come with instructions.
Yes, Your Lordship.
It will be listed again for motion.
Yes, Your Lordship.
Listed again on 19 for 2023. In this, in RFA 6, okay? The registry. Shall follow up. The order dated 15/3/2023, calling for the LCR from the court. Okay. Yes. Yes, can you call him? Yes, we have listed on next week. Okay. Never. The review file section 59 to review order to 2/11/2022 to review কৰিবলৈ মন আছে এইটো জাস্টিস সেক্টৰ মইজন এটা জাস্টিস সেক্টৰটো নাই এটা মইটো আছে বুলি এইটো মই ইনি ডাইৰেক্ট এইটো আমাৰ এইটো জাস্টিস এইটো লগত বহি কিনে ল'ব পাৰিব এইটো নাপাৰিব চিফ জাস্টিস এইটো we'll list it next week because let them get the necessary information.
Yes, Lordship.
Okay.
Yes, Lord.
We don't want to take up the matter haphazardly. Listed again on 19/4/2023.
Obliged, Lord.
For admission, item PIL Somoto 1 of 2023.
Yes.
May it please the Lordships.
Yes, Mr.
My Lords, may I take your Lordships to the last order first? The last order first, which is 13/3/2023.
Yes,
13/3/2023. May I read, my Lords?
yes.
My Lord Justice Ete,
Oh,
my Lord, the order dated 13/3/23.
yes. Yes,
May I read, my
Mr.
Lords?
Ejimon. Yes,
The work order for construction of two-lane road from Kohima to Mao was issued on 7/10/22, with a deadline to complete the work on or before 22/4/2022. As there was no progress, this court took up this PIL suo motu in public interest. During the course of proceedings of this PIL, the respondent 9 contractor had filed several affidavits, particularly stating that the work would be completed by 31/3/23. Despite the passage of time, we see that there is still no progress in the work except for about 5 kilometers of blacktopping in the existing road. We have perused the affidavit filed by the respondent number 9 on 9/3/23, wherein at para 1 it is stated as under. So this is an extract of the affidavit which is filed. Then below that, Your Lordship, after the extraction, the respondent number 9 again filed an affidavit on 13/3/23, giving reasons for the slow progress in the construction of National Highway 2 from Kohima to Mao. The relevant paragraphs are quoted here and below. Again, the relevant paragraphs, Your Lordships. And if we can skip that and come to beginning of the orders again. On 9/3/23, Your Lordships come to that?
yes.
On 9/3/23, we directed the contractor, respondent number 9, to be present in the court. The contractor is present in the court today, as well as the engineer of NHIDCL. We have taken into consideration the affidavit filed by the respondent number 9 on 13/3/23, stating that the reasons for the delay in the construction of the work. We are also aware of the orders passed by this court directing the parties to proceed and complete the work within the existing road till the ROW is resolved. We therefore pass the following orders. A, NHIDCL shall not deduct 25% from the bill submitted by the contractor respondent number 9, citing non-achievement of width as per the TCS. Clear directions, Your Lordships. There is no ambiguity as far as the direction is concerned. B, no demand for TCS will be made by the NHIDCL to the contractor, and the work will be executed on the existing road ROW. Any bill submitted by the contractor shall be paid as expeditiously as possible after joint verification by both parties. C, the contractor, respondent number 9, is directed to complete NH2 on the existing road from Kohima to Mao on or before 30/5/2023. So 30/5/2023, that is the deadline, without compromising on the quality of work. Failure on the part of the contractor to complete the work as directed here and above, costs shall be imposed upon the respondent number 9, and the NHID shall be directed to issue show cause notice to the respondent number 9, contractor for blacklisting. E, we also direct the NHIDCL as well as the contractor concerned to file their respective affidavits on the progress of the work before 12/4/23. F, we also request the learned amicus curiae to have an inspection of the work before the next returnable date and file an affidavit before 12/4/23. Now, I have filed an inspection report, Your Lordship. I have filed it yesterday. It should be in your Lordship's files.
Huh.
Inspection report. May I read, my Lords?
Yes.
By order dated 13/3/23, in the above referred PIL, this Honorable Court directed the amicus curiae to inspect the construction of the NH39 Kohima to Mao from chainage 185 to 211, design length 26.24, 9 kilometers, hereinafter referred to as the project. On 4/4/23, and proceeded to the project accompanied by the parties whose names are mentioned hereunder. Counsels for the parties, board counsels for all the parties. Then number 2, the site engineer in HRACL, the team leader, authority engineer, the resident engineer, and project managers for the respondent number 9, that is the contractor. Paragraph 1, from Nere Colony Gate in the 2 kilometers section, which is still being maintained by the state government, repairs have been carried out and the road is generally in good and serviceable condition. In 1 or 2 places, some potholes have begun to form and bituminous concrete also appears to be peeling off. This needs to be rectified so that small defects do not turn into major defects with the passage of time and the onset of the rainy season. So this is as far as the 2 kilometer stretch is concerned. Then number 2, after the above section starts the overlay section from Pesama till Kisama, which runs for about 6 kilometers. The overlay section has been completed. I asked the site engineer of the NHRECL and the authority engineer if the work in this section has been completed according to the required specifications. They replied in the affirmative. However, they stated that rectifications are required in 1 or 2 spots. The project manager of the contractor stated that he is aware of the rectifications spoken of and he would do the needful. So this is the overlay section. It is more or less complete except for some rectifications. Then number 3, the reconstruction section beginning near the Kisama gate, measuring about 19 kilometers, requires pressing attention. Much work needs to be done in this section if the contractor is to complete the project by 31/5/2023. As on the date of inspection, according to the contractor and the authority engineer, the progress of the work is as under. A, subgrade 11.1 kilometers out of 19 kilometers. GSB 8.56 kilometers out of 19 kilometers. WMM 2.7 kilometers out of 19 kilometers. DBM 1.27 kilometers out of 19 kilometers. BC 0 kilometers out of 19 kilometers. 4, the time of inspection was in and around 1 p.m. I saw a few men and/or machineries working on the project site. On my inquiry, the project manager informed me that work had stopped for the lunch hour. At the Mau Gate area, on the Nagaland side, DBM was being laid. The project manager stated that by the end of the day, a total of 700 meters would be completed. I asked the contractor the number of laborers available on site. The project manager stated that only 105 laborers are on site and that many had left. He attributed the laborers leaving to the cancellation of the contract and the floating of a new tender for the same project by the NHIDCL. So this is one of the developments after the last order of this Honorable Court. The actions of the respondents numbers 1, 2, and 8, that is, the Secretary, Ministry of Road Transport and Highways, the Managing Director, and the General Manager, NHIDCL, on this point is reflected in their affidavit filed on 29/3/2023. So this is the affidavit filed by the respondents 1, 2, and 3, stating the steps they have taken, where they have cancelled their contract and floated a new NIT. And number 6, I inquired from the NHIDCL, the authority engineer, and the contractor as to whether the project work could be completed within the 31/5/23 deadline. The NHIDCL and the authority engineer stated that the deadline could be met provided that the contractor executes the contract with sufficient manpower. They are of the opinion that the contractor would have to work day and night in 2 shifts, and that for this purpose, the available 105 laborers is not sufficient. So one of the deficiencies, as far as the inspection reports, as far as the inspection is concerned, Lordships, deficiency in the labor force. It needs to be increased, and the contractor would have to work in 2 shifts, day and night. The NHIDCL and group on one side and the contractor on the other side seem to be at loggerheads on one issue after another. I advise both the parties to attempt to resolve all outstanding issues before 12/4/2023. Now, Your Lordship, if you may go to the affidavit which was filed by the respondents 1, 2, and 8 on 29/3/23. Affidavit filed on 29/3/23.
Yes, please.
As your lordship go to affidavit,
Yes.
29/3/23, and this is filed by the respondents 1, 2, and 8. Can we go straight to paragraph 2, my lords? Paragraph 2. That the instant PIL was listed before this honorable court on 13/3/23, and upon hearing all the parties, has passed certain directions, orders inter alia directing the contractor respondent number 9 to complete NH2 on the existing road from Kohima to Mao on or before 35/23 without compromising on the quality of work. This court has also observed that failure on the part of the contractor to complete the work as directed, costs shall be imposed upon the contractor and the NHRECL to be directed to issue show cause notice to the contractor for blacklisting. Thereafter, this honorable court has directed NHRECL, contractor, and the learned amicus curiae to file the respective affidavits, inspection reports before the next returnable date, which is fixed on 12/4/23. Paragraph 3. That while the above mentioned directions being in operation, the deponent respectfully states that the instant affidavit is necessitated to file owing to certain developments with regard to the contractor, respondent number 9's conduct in violation of the provisions enshrined in a contract agreement, more particularly with regard to submission of non-genuine bank guarantees, wherein the authority has issued notice for intention to terminate the contract on 16/3/23 under clause 23, serial number NNO of the contract agreement. Number 4, that at the outset it is stated that the NHRECL and the contractor signed an EPC agreement on 17/20 for the work, upgradation, etc., under Bharat Mala NH0 TSP in the state of Nagaland in EPC mode at the contract price of rupees 167, 2 crores 23 lakhs 8,200 with construction period of 18 months commencing from the appointed date. 5, that due to non-availability of encumbrance-free land and due to high costs of damage compensation determined by the state government, the authority, this may also be noted, Your Lordship, this is important. I wish to address Your Lordships on this issue because this is the root of the problem. That due to non-availability of encumbrance-free land and due to high costs of damage compensation determined by the state government, the authority, with the permission of this honorable court, decided to reconstruct the existing two-lane Kohima Mao Road within the available ROW instead of two-lane with paved shoulder through the existing corrector. Now, again, Your Lordships, may kindly note, the direction of this honorable court, repeated from time to time, is that the construction should begin on the existing road until such time the land acquisition matters are resolved. It is not simply a direction that only the construction should only happen on the existing road. The road should be constructed on the existing road, and in the meantime, the acquisition matter should also proceed. So there is no direction that the work should be reduced as far as this honorable court is concerned. But apparently, the respondents 1, 2, and 8 seem to be under the impression that the scope of the contract has been reduced. It has not been reduced. The same has been accepted by EPC contractor, and accordingly, the proposal for descoping, again, Your Lordships may kindly note, the respondents 1, 2, and 8 they seem to be under the absolute impression that the contract has been descoped. The proposal for descoping of the paved shoulder of Kohima Mao Road with financial implication worth rupees 47 lakhs, etc., was approved on 27/5/22 as per the recommendation of the authority engineer. That, however, due to slow progress of work and poor planning of the work of EPC contractor, the NHRECL, by letter dated 14/11/22, issued show cause notice to EPC contractor to declare as non-performer in accordance with circular dated 6/10/21, whereby the EPC contractor was given 15 days time to furnish its reply before declaring as non-performer. However, the EPC contractor has failed to reply against the said notice despite a lapse of more than 15 days. 7, that consequently, the authority, by letter dated 13/2/23, declared the EPC contractor as non-performer in terms of the aforesaid circular dated 6/10/21. That the deponent respectfully submits that the certified bank guarantees submitted by the EPC contractor against a performance guarantee amounting to such and such, valid up to 8/12/22, and additional performance security amounting to such and such, valid up to 8/12/22 for the project were found to be non-genuine. That the deponent humbly submits that the authority, by letter dated 16/12/22, asked the contractor to prove the genuineness of the bank guarantees, into which the contractor, by its letter dated 24/12/22, has responded to the same. However, on examination of the same, it was found to be not satisfactory. Thereafter, by its letter dated 5/1/23, the authority has requested Punjab National Bank for encashment of the bank guarantees, wherein the bank, by its letter dated 17/1/23, has issued an adverse remark on the subject matter, the relevant part of which is reproduced herein below. PNB has neither issued these bank guarantees nor confirmed these bank guarantees under MT 60 of SFMS, and as such, these guarantees have no legal binding. PNB denies any liabilities under these purported guarantees. 10. The deponent humbly states that the contractor has breached clause 23.1 NNO of Article 23 of contract agreement. The relevant part of the provision is reproduced here and below for its court's ready reference. Then we can proceed straight away, Your Lordship, to the next page. Consequently, the authority, by its letter dated 16/3/23, issued for intention to terminate the contract to the EPC contractor. So this is after the order dated 13/3/23 passed by the Honorable Court. Lordships may kindly note the dates. So on 16/3/23, a notice of intent to terminate the contract was issued to the EPC contractor. 11, that the headquarters in HIDCL, by its letter dated 17/3/23, has communicated to the ED, Regional Office Kohima, Nagaland, regarding the issuance of notice for intention to terminate the contract to the EPC contractor, and also directed the ED Projects NHIDCL Regional Office Kohima to apprise the Honorable Court with regard to the proposed action of the authority. That in response to letter dated 23/23, the HQ, by its letter number such and such dated 23/3/23, reiterated that EDP Kohima shall apprise the Honorable High Court of Gauhati, Kohima bench, regarding the proposed action of NHIDCL, and an application may be moved before the Honorable Court of Gauhati for seeking permission to terminate the contract on account of submission of non-genuine bank guarantees by the EPC contractor. That the opponent respectfully submits that the authority has highest regard with the direction issued by this Honorable Court, and on 13/3/23, and hence your humble deponent deems it fit and proper to apprise this Honorable Court on the aforesaid development for your Lordship's indulgence, and to pass appropriate and necessary orders in the interest of justice. Now, your Lordships, though it has not been mentioned here, it would appear that the notice to terminate the contract has been acted upon by the NHIDCL, and the contract has been terminated, and this is the information I'm getting from the parties, and a new NIT was floated. Now, as far as the allegations in this affidavit are concerned, your Lordships, the contractor has filed his affidavit. In his affidavit, he has stated the progress of the work as on date, and he has also explained what the allegation in relation to the BG, bank guarantee. And apparently, again, from what the parties have told me, the bank guarantee issue is closed to the satisfaction of all the parties concerned. It is mentioned in the contractor's affidavit also. A new affidavit has been filed, a fresh affidavit has been filed this morning by the NHIDCL. And I would like to take your Lordships to that affidavit, because this goes to the root of the matter, your Lordships. This goes to the root of the matter. An affidavit filed this morning. Have your Lordships got it?
Yes.
Yes. If you may go straight to paragraph 9. May I read, my lords? Paragraph 9. That in regard to the acquisition of land for the upgradation of existing road to 2-lane with paved shoulder for Kohima Mau Road, survey for 2-lane road was carried out as per the DPR prepared by the DPR consultant, and NHIDCL has requested the state government to provide the required ROW for widening the existing road as per the specifications. As the land and resources belong to the people under the provisions of Article 371A of the Constitution, and Article 371A does not allow the ownership and transfer of land and its resources. Also, no cadastral maps are available with the state government, which makes it difficult to acquire land as per the provisions of the National Highways Act 1965 or the Nagaland Land Requisition and Acquisition Act 1965. However, as per the policy of the government of Nagaland, the respective owners are compensated for the standing properties, crops, plantation, trees, vacant building plots, etc., as per the rates approved by the government. State government, by DO dated 6/8/2020, has stated, with the aim to have faster development of intrastate connectivity of projects, land free of cost for two-lane projects in Nagaland have been adopted on an alignment passing through existing road, and compensation is being catered for all types of damages. Copy of DO letter dated 6/8/2020 is annexed and attached at Annexure 5. Now, if you may pause here for a moment, Your Lordships. If you may pause here for a moment. The respondents 1, 2, and 8 are using each and every provision of the National Highways Act of 1956 and leaving out only the provision relating to acquisition of land. Now, this is, Your Lordship, I am bringing this point up because this is the root of the problem. This is the root of the problem. Right from the very inception, the contract has not been able to be executed because the procedure prescribed by law for acquiring the land and for providing the appropriate ROW in terms of the contract specifications, that has not been done till date. Now, this statement about Article 371A, Your Lordships, this is an area of grave concern, an area of public interest which needs to be resolved, Your Lordships. And for that purpose, Your Lordships, there is a book called the Nagaland Code. I have printed out the relevant pages, Your Lordships. This is the Nagaland Code, Volume 1, the 2004 edition. May I take Your Lordships to the provisions of this code and to certain enactments within this code. Now, this is the 2004 edition, Your Lordships, and Your Lordships will come to Schedule 5 on the third page. Have Your Lordships got that? Schedule 5 on the third page. These are just copies from the Nagaland Code, Your Lordships. So, Schedule 5, it says, list of central acts in force in erstwhile Naga Hills, Twensang area, immediately before 1st December 1963. That is the date of statehood. And Your Lordships may kindly come to the next page
National Highways Act 1956.
at serial number 48.
Yes.
Then, Your Lordship, we turn to the next page, and this is the Naga Hills Twensang Area Act. The State of Nagaland Act, Your Lordship. Where did you get this? If you can come to page, section 26. Section 26. Has the Lordship got that? The second last page. Second last page. Continuance of existing laws and their adaptation. Has your Lordship got that?
Yes.
Section 26. All laws in force immediately before the appointed date in the Naga Hills Twensang area shall continue to be in force in the state of Nagaland until altered, repealed, or amended by a competent legislature or other competent authority.
Yes, now, Mr. Ejimomi, but this is not the time for the respondents to raise all these issues.
No, it's not a question of raising these issues, Your Lordships. It's not a question of raising these issues.
No, what I mean to say is that now it is not for the NHIDCL to
Yes.
raise all these issues.
Yes.
That's what I'm saying.
Yes, my lord. Yes, my lord.
We have come a long way.
Yes, my lord.
We have come a
But
long way.
They are still persisting on this stand, Your Lordship.
We will not accept that.
Yes, my lord. So Your Lordship, so the first point is,
The only pertinent question now is to comply with the order dated 13/4/2023
my Lord,
before this court.
yes, ma'am.
Other issues, of course, after the order dated 13/4/2023 ceases.
13.3, my Lord.
23.
13.3.23.
13/3/2023, yes.
But Your Lordship, why I'm mentioning this is because along with the direction to continue work on the existing road, there is also a direction to go ahead with the acquisition,
Correct.
which they are not doing, saying that this is the obstacle. And in terms of the National Highways Act, Your Lordship, it is the duty of the Union of India unless this issue is resolved, Your Lordships, the providing the ROW required for the specifications for the contract, it is not going to be possible.
Yes, Mr. State Government. Your ROW has been long pending. You were supposed to take up the matter with the state government regarding the acquisition of the land.
Your Lordship, here I have stated in my affidavit dated 7 March that NHIDCL is the agency by which agency they have to approach the state government for acquisition and requisition. So it was not approached by the NHIDCL. So unless it is done by the agency, then we are helpless.
NHIDCL has not still approached the state government
No,
for acquiring the land.
yes. It is clearly stated in the affidavit, para number 10.
And what is NHIDCL doing till date?
Now,
We have come a long way. I think all these issues are supposed to have been resolved.
Your Lordship, here in my affidavit, I have annexed the minutes of the meeting. That is my, in my affidavit dated 7 March, Annex B, that is a minutes of meeting chaired by the Honorable Chief Minister of Nagaland on 4th March 2020. So there they have discussed that in the mountainous area, NHIDCL, they don't want to venture out a 4-line. So they have decided that they have to maintain only the existing road. That was the resolution of the meeting. So I have annexed that the minutes of the meeting.
Whether NHIDCL has the copy of that resolution, why they are bringing up this issue time and again?
Made this
Yes,
lordship.
Mr. Moore.
Lordship, with due respect to the additional AG lordship, the document that he has relied upon, lordship, it happened in the month of March 2020, lordship. Lordship,
March
the 2020, lordship.
Okay.
Now, lordship, I filed an affidavit this morning, lordship. I have produced a document, a decision made on 6th of August 2020, lordship. Subsequent to that, lordship. Subsequent. Now, this document pertains to the communication made by the Chief Secretary of the State. The NHIDCL was apprised that there is a system, lordship, in the state of Nagaland that the projects, whatever the project undertaken by the NHIDCL, lordship, there is a practice that the land is given free of cost, lordship. That has been specifically, categorically mentioned in the decision, lordship. Now, lordship knows very well about the provision, lordship. NHIDCL, we are only the implementing agency, lordship. The central government and the state government should take a call on this, lordship. Now the state has already taken a decision and
Now the
conveyed
blame
same.
game has started.
No, lordship, I have no intention to blame, lordship. This is the document. This is the decision of the state, lordship, as far as the land acquisition is concerned. Just
What
for
is- what was decided by the state? To
just
keep
for just
land
for
free
a
of cost.
moment, lordship, if I may be allowed to turn to page 19, the affidavit which I filed this morning, lordship, affidavit filed by respondent number 2 and 8. Just for a moment, lordship, it is just a one-page document, lordship.
Now, like the earlier times, why are we going back and back and back again?
Lordship,
Why don't we go forward?
exactly, lordship, and lordship, with due
Your
respect,
Lordships,
lordship.
if I may, unless the ROW issue is resolved, the contract will never be completed.
No, that issue is still there. That issue is still a live issue. But
Yes, Your
actually,
Lordship.
the order was passed by this court was to actually complete the work
On the
within the existing ROW.
Existing
Exactly,
ROW.
lordship, and
And
on
So at
2 and
least
3
to that
occasions,
extent
lordship,
for the commuters.
2 and 3 occasions, lordship.
And coupled with that, Your Lordship, the acquisition process should also go on. That part they are not doing, Your Lordship.
Lordship, with due respect, Lordship.
And the affidavit
With
filed
due respect,
today,
we are alive to the
the affidavit filed
facts,
today,
Lordship, and the directions passed by this honorable court.
the
Lordship.
affidavit filed today
With
shows
due
that
respect to the
the
learned
respondents
amicus, Lordship,
think that the
he has
Please,
misconceived,
just a
Lordship.
minute. Just a minute. The affidavit filed today shows that they think that the scope of the contract has been reduced.
No,
The-
no,
Lordship,
The
no,
acquisition
Lordship.
part is
That is
not
not
more.
The
Lordship.
scope of the contract has not been
No,
reduced.
Lordship, yes. We are alive, Lordship.
It
To
is
the
only
directions of this
pending
court.
acquisition.
Exactly, Lordship.
Pending acquisition
Exactly,
that
Lordship.
you were directed by this court
Lordship.
to complete the work within the existing order.
Yes.
Lordship. We are alive to that, Lordship.
No, the affidavit doesn't say so, Your Lordship.
And
The,
Lordship,
the previous affidavit says that they have reduced the scope of
So,
the contract by
Mr.
47
Mr.
crores.
Moa,
Lordship.
see, let us not confuse things. We are all actually, this PIL has been filed
Lordship.
in public interest.
Lordship.
Yes.
And we are all there for public interest.
Lordship. Lordship.
So why don't we at least let us see, of course, land acquisition proceedings, this may take some time.
Lordship.
This may take some time.
Lordship.
We have not abandoned that. But at least the directions passed by this court
Lordship.
to complete the existing ROW.
Yes, Lordship. Yes, Lordship.
At least let us, to that extent, let us see that the work is completed.
Lordship. If I may be allowed to,
So
Lordship.
if we are to again go back to all your affidavits,
Lordship.
then in that case, we are back to square one.
Lordship. As
We
far as-
are not advancing.
Exactly, Lordship.
In fact, we are
I
going
agree,
backwards.
Lordship. I agree, Lordship. Lordship, as an officer of the court, Lordship, it is my responsibility, my duty to apprise this court, Lordship, what has happened. Otherwise, Lordship, the chapter of this notice for intention to terminate is already closed, Lordship. It is our responsibility to apprise before this honorable court what has happened, Lordship, after 13-3. Otherwise, we are alive to the direction. And Lordship, we have also taken our initiative because this is not an arbitral proceeding. All the stakeholders, it is our collective responsibility,
Correct.
Lordship.
You're right.
It's a collective responsibility. Now, Lordship, what we have initiated, observing what has happened, Lordship, the progress made by the contractor, Lordship, for the last 6 months. Lordship, we kindly appreciate this. For the last 6 months, only 16%. That is the progress.
1/6.
1/6, Lordship. 1/6. We are concerned with this. Now, Lordship, what?
For the whole stretch.
Yes, Lordship.
For the whole stretch.
For the whole stretch.
Mr. Jimomi, is it correct? Only 16%?
And to be
From
specific,
the
Lordship, to
affidavit
be
filed
more
by the authority
specific,
engineer, that is not correct, Your Lordship.
to be more specific, Lordship, in the month of March, after passing this direction on the last occasion, 13th of March 2023, only 0.5%, Lordship. That is the progress. In fact, Lordship,
No.
these issues has to be
See,
addressed.
that actually, the order dated 13-3,
Lordship.
whether actually the contract is seriously on the job or not, the order dated 13-3 takes care.
Lordship.
Because there actually a deadline has been given.
Lordship. In fact,
To the
we are,
contractor.
Lordship, concerned with that, Lordship.
Yes.
And Lordship, if your Lordship may kindly appreciate, we have tendered, in order to help the contractor, Lordship, we have tendered bid on 2 occasions, Lordship, for repair and maintenance, so that the project will be completed on time, Lordship. It is not a case that we have terminated a contractor, but seeing the progress of the work, Lordship, we have tendered on 2 occasions for maintenance and repair, Lordship. If your Lordship may kindly note that.
No,
For
but
the last 6 months.
Don't you actually think that would go against, your action would go against the order dated 13-3?
Lordship, that has happened before this order dated 13-3, Lordship. That has happened.
That was never brought to the notice of this court?
Lordship.
That was never brought to the notice of this court? This is a new development.
Lordship, that similar measures were taken even in the other PIL which is pending before this honorable court. And this,
Forget about that. That
this-
we will take care when the matters are listed.
yes, Lordship.
This case,
Lordship.
in this case, you have never brought that issue before. This is, I think, this affidavit is the first time. You are
Lordship.
bringing this to the notice of the court.
In fact,
All along, actually, you were actually participating in this case before this court, and you have never brought that issue before the notice of this court.
Lordship, that is as per the contract agreement, Lordship. That is part of the contract agreement, Lordship.
The court insists of this matter.
Lordship.
And when the court insists of this matter, each and every development ought to have been brought to the notice of this court.
Lordship.
Now, every time the matter is listed, you are bringing a new development. How can this case progress?
Lordship, that measure was taken, Lordship, in order to assist the contractor, Lordship.
That's all right. Everything is for public interest.
Lordship.
But actually, your way of doing things
Lordship.
is also not proper. See. Your
Lordship,
way of doing
as an
things
officer of the court, it is my duty to apprise this court what has
You could
happened,
have
Lordship.
apprised before.
Lordship.
You could have apprised before.
I was instructed this morning, Lordship, and I have received a verbal
That means,
instruction, Lordship.
The authority is not playing clean.
Now, Your Lordships, if I may, Your Lordship, the scope of in brief, the scope of the National Highways Act 1956. Now, it is the duty of the central government to declare national highways. It is the responsibility of the central government to declare national highways. Secondly, it is the duty of the central government to build, operate, and maintain national highways. And whenever land is required for national highways, it is the duty of the central government to acquire. That is the first step, my lords. That first step has never been done by the respondent number one, which is the central government. That step has never been done. And because that step has not been followed, we are landing up in this soup now. And that issue is yet to be resolved. And what is the NHIDC
We have
relying
no
upon?
other option, but pending a resolution of that issue, I think we have to.
Yes,
go
Your
ahead
Lordship. As far as the
with
existing
orders
road is
passed by
concerned,
this court.
now, Your Lordships, as Your Lordships has rightly pointed out, some mischief is going on somewhere. In the affidavit filed by the contractor, there is a very interesting document. Your Lordship may kindly see that. The affidavit filed on today. There is an affidavit filed today by a contractor. Respondent number 9 at page 10. At page 10. At page 10. Have your lordships got it? This is apparently an email written to the contractor. Or it's an intra-communication between the authority engineer and the NHIDCL. This is dated 15 March 2023. This is after the order, Your Lordships, after the order of this Honorable Court. Here, sir, you are instructed not to start any new stretch until you are sure to complete the stretch till present exercise of identification of stretches that can be completed without hindrance. Please also cooperate in completing the exercise fast as instructed by ED letter will follow. So even the existing road,
This is addressed to,
this is addressed to Kohima Mau Gmail. This is project manager of the NHIDCL. And this is written by the authority engineer. So though it is addressed to the project manager, it prohibits the contractor from executing any work on the existing road.
see, Mr. Moa,
Lordship.
when the matter is pending, when there is an order passed by the court,
Lordship.
writing all these communications is only stifling the orders passed by this court. And that would invite a contempt also.
Lordship, I was then
And
aware of this
and so, my
communication,
lord,
Lordship.
apparently realizing the error of their ways, in the affidavit filed by the 2 and 8 today, at paragraph 11, your lordships can come to paragraph 11. The affidavit filed by respondents 2 and 8, affidavit filed this morning. The earlier affidavit I was referring to, your lordship,
By respondent number?
2 and 8.
Okay. Yes, Mr. Ichmo.
Paragraph 11, my lord. Paragraph 11, my lords. Paragraph 11.
Yes.
That the EPC contractor has been directed to complete the targets as committed before the Honorable Court on war footing. In this regard, the contractor needs to enhance the pace of work and start to work on both day and night shift in the interest of completion of the project as per Honorable Court's directions. However, maintenance and remarkable physical progress at site is yet to prove. So now the contractor has been directed to execute the works. So they must have realized the error of their ways and tried to make amends by filing this affidavit this morning, Your Lordships.
Yes, Mr. Joshua,
My lords,
the honors lies on you now.
yes, lordships, if I may kindly be allowed to take your lordships to my affidavit filed
Yes,
this morning,
please.
the respondent number 9 affidavit.
Respondent number. Respondent number. Okay.
May I take your lordships to paragraph 2 at page 2? It's a short affidavit, if my lords may kindly allow me to read through it.
Please, please.
That pursuant to the order dated 13/3/2023, passed by the Honorable Court, the EPC contractor has been sandwiched and has been subject to terms and conditions beyond his control by the concerned authorities. The facts are projected as hereunder. Roman 1, White order dated 13/3/2023, this Honorable Court issued a clear direction that the NHIDCL shall not deduct 25% from the bill submitted by the contractor, respondent number 9, citing non-achievement of width as per TCS. But the bill amount of rupees 4.78 crores recommended by the authority engineer has been deducted, and an amount of rupees 3.36 crores only was released on 27/3/2023. That is, after the order of this Honorable Court. Deduction has been made, despite the direction of this Honorable Court. There is deliberate and intentional disregard and violation of this Honorable Court's order, which this Honorable Court may kindly take note. Next, Lordship. Roman 2. Subsequent to the order dated 13/3/2023, the ED, Executive Director, Projects, NHIDCL, the authority engineer and the contractor visited the site on 14/3/2023. Thereafter, the ED Projects advised to re-verify the available width of ROW on 15th March and 16th March, so that necessary decision could be taken. Therein, the authority established the fact that only 4.591 kilometer stretch having ROW width of more than 11 meters was available to comply with the requirement of hill manual, and the balance 15.103 kilometer stretch, if executed, will fail to meet the minimum requirement, that is as per the TCS, Lordship, which this Honorable Court said do not insist on TCS as per the order dated 13/3/2023. But still, on 14, Lordship, it was insisted that on 15 and 16, necessary decision should be taken after re-verifying, Lordship. So TCS is still insisted. Consequently, the authority engineer, White email letter dated 15/3/2023, instructed the contractor not to start any new stretch till the present exercise of identification of stretch can be completed without hindrance. In other words, the authority engineer meant that where the roads does not meet the TCS specification should not be touched. This is also in clear violation of the direction of this Honorable Court, that is to finish the work as per the existing road. The contractor cannot violate the direction of this Honorable Court, and also cannot go against the authorities, Lordship. Can kindly understand the predicament of the contractor, Lordship. Then next, Lordship. Despite the clear direction of this Honorable Court giving time till the month of May 2023 to the EPC contractor to finish the work, the respondent NHIDCL issued a notice of intent to terminate the contract, White letter dated 16/3/2023, just 3 days after the order passed by this Honorable Court, by harping about a dead issue of non-genuine bank guarantee related to foreign bank guarantee and slow progress of work. This Honorable Court may kindly appreciate the fact that as per clause 2.21.1 of the A of the RFP of the contract agreement notified at the time of floating the tender, that is 2/7/2020, Lordships, which deals with the submission of performance security, it is stipulated that in case the bank guarantees issued by the foreign bank outside India, confirmation by any nationalized Bank of India is required for avoidance of doubt. Scheduled bank shall mean a bank as defined under Section 2E of the Reserve Bank of India Act 1934. Accordingly, the EPC contractor submitted a foreign bank guarantee which was received by authenticated SWIFT message and duly confirmed by the local scheduled bank PNB in this case. It may humbly be submitted that NHIDCL on its part as mandated, duly carried out extensive and comprehensive procedures and practices to establish the genuineness of the said bank guarantees, and only after having confirmed and satisfied itself in this regard that NHIDCL entered into a binding contract agreement with the contractor, which is 2 years back. After 2 years, they brought out the issue, Lordship. As such, the authority is stopped from now blaming the contractor, and the allegation that we have furnished non-genuine bank guarantee is devoid of logic and common sense, wherein it is guilty of contributory negligence, as also the fact that the contract tenure of the said BG has since expired, Lordship, and additionally, a fresh BG has been submitted as required. The BG which is now under issue, Lordship, by
Whether at this juncture,
Lordship.
your contract has been terminated. Whether at this juncture, at this
No, Lordship,
point of time,
they said they will keep it on hold for a time being.
they have actually given the notice of their intention to terminate.
Yes, Lordship.
Correct.
My Lord.
But whether they have terminated.
No, not yet, Lordship.
Mr. Moa,
Lordship, we have not acted upon, Lordship.
yes, and please don't act
Lordship,
till the order dated 13-3 ceases.
Lordship.
Okay?
May I be allowed to
Thereafter,
continue?
we have given you the liberty also.
My Lord. May I continue, Lordships? So it may be appreciated by the Honorable Court that as mandated by the contract agreement on expiry of the earlier bank guarantee, which they are now making an issue, Lordship, fresh bank guarantee towards performance security was furnished on 8/12/2022, Lordship. The same date whereupon the bank guarantee furnished earlier was expiring.
So,
So,
Mr. Joshua,
yes, Lordship.
if we have to go back to all these issues,
Yes, Lordship.
we will never complete the work. We will never complete the work.
Yeah, but Lordship, that is the ground why they have given us the termination notice.
Notice has been given,
Yes,
but
Lordship.
it has not been acted upon.
My Lord, Lordship. Anyways, Lordship.
So what is your progress to the order dated 13-3?
My Lord, I may
Let us-
kindly be
because
allowed
actually,
to.
the learned amicus curiae,
My lord,
actually, on that 16-kilometer stretch,
My lord.
16,
19 kilometers.
19, the work is not at all satisfactory.
Oh, Lordship, we are taking the percentage of the overall stretch, not the portions where we are not allowed to work now, Lordship.
Who has not allowed you?
Lordship, the NHIDCL or,
Whether this court has allowed you,
yes, Lordship.
then you go by this order.
My Lord, at the end of the day, my Lord, will kindly appreciate this fact also that we're working for them. And when they,
You are working for
Yes,
the
Lordship.
public.
my Lord,
You are working for the public. Mr. Moa, I think you should not tell your officers not to create all these obstacles.
Lordship.
What we all want is the completion of the road.
Lordship, Lordship. I'll advise, Lordship.
So at least advise your officials not to push this obstacle, that obstacle, despite the orders passed by this court.
Lordship.
At least allow the contractor to work peacefully and let us see whether they are really serious or not in their work.
Yes.
At least. But if you time and again put obstacles, it is becoming a very good excuse for them.
Exactly, Lord.
You come to the court with all seriousness. Come to the court with all seriousness.
Lordship, Lordship.
If you are not serious, then why make submissions?
My lords, my lord, your lordships, may kindly allow me to read 3 paragraphs of my affidavit.
No. We'll just. I think I don't want to go back to all this.
No, my lord, I'm not going back. It's a practical problem faced now. If my lords may kindly extend your 1 minute
You
patience.
go by the order passed by this court. Yes. Beyond that, we cannot order anything.
No, my lord, the practical problem that we are facing
You
now.
go by the order dated 13-3.
No, I'm not going against that, lordship.
If you are not going against that, you go by that.
Now, lordships, after the termination intent and the floating of the bid documents have been issued, 40 technical experts of my firm, they have left. And further, 25 skilled bitumen laborers without whom I cannot lay the carpeting, lordship, they have also left. Now I'm trying to again gather the laborers from here in your lordship. My lord, these are the result of the action of the NHIDCL, lordship. And this fact, if my lords may kindly consider, it cannot be ignored because these are the practical problems faced by the contractor,
Jimmy,
lordship.
My lord.
Kindly address this court as to how this court is to go about on the new NIT issue.
Your lordships, an affidavit has been filed this morning. An affidavit at paragraph 11, which I was referring to, your lordship.
Affidavit by?
By respondents 2 and 8, the very same respondents on whose behalf submissions have earlier been advanced.
Yes.
2 and 8. Respondents 2 and 8. Yes. So at paragraph 11, that the EPC contractor, paragraph 11, that the EPC contractor has been directed to complete the targets as committed before his honorable court on war footing. In this regard, the contractor needs to enhance the pace of work and start to work on both day and night shift in the interest of completion of the project as per honorable court's instructions. So here is a clear statement that they are also going to abide by the instructions of the court. So the matter ends there as far as the NIT is concerned, and we will hold them to this statement in the affidavit. If they violate this statement, Your Lordship, they will be liable for consequences. Respondents 2 and 8. As Your Lordship was commenting, they cannot
And,
say one thing.
Mr.
by affidavit.
Joshua, your client is always giving very good excuses. What is the progress? Tell us.
There's an affidavit.
What is your progress?
Lordship, the progress report has been filed at Annexure A, Lordship. As on today, Lordship, we are not creating excuses. In fact, most of our technical experts have left us and we are still
You
trying
are
to work,
making
Lordship.
that submission. I have been hearing your case. I have always heard you making excuses. That's why I'm raising this issue. Where's your progress? Let's
Lordship,
see.
kindly turn to page 9, Annexure A.
Huh.
Married, Lordship,
Yes.
the work description EW up to subgrade top. Total quantity as per revised scope, that is 19.094 kilometer. Total work done is 11.180 kilometers, Lordship. That is 58%. Then number 2, Lordship, GSB, 19.094 kilometer. Total work done 8.562 kilometers. That is 41%, Lordship. Number 3, WMM, 19.094 kilometer. 3.224. That is 17%, Lordship. DBM, 26.794 kilometer. That is the total work done is 8.0874 kilometers, 30%. BC, 26.794 kilometers. Total work done 5.640 kilometers, 21%. Culvert widening 54 nose. Work done, total work done 14, that is 25.90%. Culvert reconstruction 48 numbers. Total work done 23.5, that is 49%. Repair of existing minor breaches 5 numbers. None has been done, Lordship. Roadside drain 26. Total quantity as per revised scope, that is 26,220 RMT. I don't know what is RMT, Lordship. Total work done 2,050, which is 7.82%. Number 10, road marking 26.169 kilometers. Total work done 5.640 kilometers, that is 21.60%. Number 11 is bus shelter base. Total quantity as per revised scope, 1 numbers. So 1, it's not done yet, Lordship. Roadside plantation, nothing needs to be done, Lordship. Retaining wall, total quantity as per revised scope, 6,024 RMT, 271 done, that is 4.50%. Breast wall, 1,010 kilometer. 1,010, I don't know why kilometer, Lordship, I do not understand the technical term. But here 471 is done, that is 47%. Surfacial protection and erosion control, 220 RMT, nothing done. Hydro seeding and mulching, 10,000, it's not done as yet. Metal beam crash barrier, 12,909, 0% done. So that is the progress as on today, Lordship.
So the progress is not very satisfactory, as
Yes,
you can
Lordship.
see it. As you can see it.
The authority engineer's report is more clearer, Your Lordship. And in terms of the authority engineer's affidavit filed today, authority engineer is the respondent number 10. Respondent number 10. If Your Lordships will turn to page 3, the physical progress is 25.85%
Overall.
overall,
Overall.
25.85%. So, Your Lordships, coming back to the earlier point about the issuance of the fresh NITs. Your Lordships, there is a standing order of the Honorable Court saying that the contractor will execute and finish the work. That is a judicial order, Your Lordships. The respondents, the NHIDCL, the respondents 1, 2, and 8, they cannot sit and appeal over a judicial order of the Circuit Court by an executive order. The NIT itself is void ab initio, Your Lordship. So as far as the respondents 1, 2, and 8 are concerned, they must take remedial action by themselves, even without any intervention from the Circuit Court, or otherwise face contempt.
Mr. Moa,
Lordship,
you will have to properly advise your client
Lordship,
because apparently,
Lordship,
prima facie, there is contempt on your part.
Lordship,
You have not brought it to the notice of this court.
Lordship,
But as per what transpires
Lordship,
from your submissions, obviously there is a prima facie contempt. We don't want to take action.
Lordship,
If we go on taking action, our prime object to achieve the target
Lordship.
will be sidelined.
I agree, Lordship.
Because seeing your affidavit, you have actually directed the contractor to complete the work as per the direction of this court.
Yes, Lordship.
On the other hand, you are issuing fresh NIT for maintenance development.
Lordship.
What is this? So,
I'll appraise my client, Lordship.
prima facie, there is a contempt.
Lordship.
So it is incumbent upon them to take some remedial action now, Your Lordships.
So, Mr. Joshua, is your client going to complete the work within the time frame?
Yes, Lordship.
You don't have to give any excuse saying that this NIDCL is saying that, this authority is saying that, this authority is giving us this direction. I think there is an order passed by this court.
That
Do
is
you, do you have no faith in the order passed by this court? Do you have no faith?
no, Lordship, it's not a case like that.
See, we have passed an order.
No, no, my Lord.
And that
Yes.
extension of time was also granted on your request.
Yes,
And
Lordship.
on your request, time and again, the time has been extended. Time and again, the time has been extended. And beyond what we have actually directed by 13.3 order, we cannot go further. You will have to safeguard the interest of
Lordship,
your client.
that is fully understood. Immediately after this Honorable Court has passed the order, now the developments I have shown you, Lordship, 65 of my expert laborers have left, technicians and skilled laborers. No, Lordship,
It seems your contractor has no faith in the orders passed by this court.
it is not a contractor, Lordship. All the workers, the technical experts, the expert skilled laborers, Lordship, they are aware of the developments. They say there is no hope that we'll be able to continue with the work. They have just left like that. I cannot stop.
So you now mobilize. If they have left, you are supposed to mobilize because actually we cannot change the orders passed by this court.
Yes, Lordship.
We
But
cannot change it.
my lords may kindly take into consideration the practical difficulties that has been
No,
as a result of the action of the respondent in
I
HIDCL,
will
Lordship.
consult with my brother and we will pass orders, but
No,
we
no.
will take care of all your apprehensions. And we will also give a direction to the NHIDCL not to take any coercive actions, but to comply with the order dated.
Yes.
So please do it. And then wait for at least for 35/2024. After that, we have given you liberty to issue notice and to blackmail the contractor.
No,
If
my
it
lord,
is found, if it is found that he has not completed the work as per the direction of this.
at the moment, Lordship, that would be grave injustice to the contractor
No
because
grave injustice, no grave injustice. The order is there. We are not going beyond that order. If I am telling you, if I am actually making any observation beyond the order, of course, I will prejudice you. But if I am making any observation within that order,
if the NHIDCL is given the liberty to take
no, you cannot.
action on us, Lordship, that would
You
be a
cannot
prejudice
take-
to the
you
contractor,
cannot-
Lordship.
You cannot, we will actually uphold that order. And then we will not allow you to grant any excuses and we will also not allow NHIDCL to take any steps beyond the order 13.3. If that instance come to our notice, then we will have to issue contempt notice. So you please advise your client. Okay,
Yes, my lords.
for the time being, let us keep.
Your Lordships, just so that all factors are taken care of. Now, only 105 laborers are there. The authority engineer is present today. If we can inquire of him what it would take what it would take in terms of men and machineries so that the work can be completed by the 31st May deadline.
Say, Mr. A. Jimami, I think our orders are very clear.
My lord.
And actually, the order has to be abided.
Yes, my lord.
So it is not for us to remind the contractor again and again that this much of manpower will be necessary, this much of machineries will be necessary. See, it will not be proper for us to remind the contractor again and again. The contractor is well seized of the order passed by
Yes, my
this
lord.
court,
Yes, my
and the contractor should go by this order. And the NHIDCL should also see that there is no obstruction caused to that order for the contractor to implement the work.
My lords, may also kindly take note that bills have been deducted despite the order passed by the Honorable Court, Lordship.
We will go by that order, 13.3, not to deduct. Yes, we will pass, I will consult with my brother and then we will pass the order.
Very well, my
My
lord.
lord.
Yes.
Lordship, Lordship.
Item 5 to 38, PIL 35, 2017.
May please lordship.
Yes.
If my lord may kindly see the order dated 15/3/2023. 15/3/2023, your
Yes.
lordship. So by this order, your lordship, a committee has been constituted to inspect the site
Ah,
and also to verify as to whether
yes.
the progress of the work, the status of the work as given in the affidavit which is filed by the Department of Health and Family Welfare, your lordship, that's number 4, whether it is correct or not, your lordship. So accordingly, your lordship, the committee, the team, we have inspected the site, your lordship. May I take your lordship to page 3 of that, and we have filed an affidavit as directed by this honorable court on affidavit filed on 27/3/2023, your lordship. Now,
Affidavit on behalf of independent committee.
lordship, may I take your lordship to page 3? Page 3, your lordship. Para 4 is the date on which the team has visited. 22/3/2023, your lordship.
Yes.
The team visited the site for inspection. And relevant paragraph, may I take your lordship to next page, para 5. There, your lordship, we have given the table. The chart is there, your lordship.
Yes. Yes.
Now, serial number 1, second column is medical college building. Now, as per the affidavit file, the percentage of work completed is 80%, your lordship.
Yes.
Now, the status of the work, your lordship, as when the inspection team has visited the site, your lordship, that is as per the affidavit, your lordship. That's also 80%, your lordship.
What, Mr. TB?
Lordship,
What is this NMC norms? NMC?
National Medical Council.
Okay. National Medical.
Now, commission, your lordship.
National Medical?
Commission, your
Commission.
lordship.
Okay.
Now coming to, now your lordship, regarding the boys and girls hostel, your lordship. In the affidavit, they have given the second one, they have given 80%, and we have found, team also found that the work completed is 80%, your lordship. Now, except for number 4, 200 square meter apartment, your lordship. Second page, page 5, serial number 4, your lordship. Except for this, in the affidavit, they have stated that 70% of the work is completed, but the inspection team has found that no, the work completed
Lesser than 70.
is less than 70%, your lordship. However, in the comments, your lordship, the inspection team is given assurance that the entire work will be complete and hand over by May 2023. However, the immediate need for accommodation is alternately arranged in 100 square meter apartment until the completion. Your lordship may kindly see serial number 3. Serial number 3 is 100 square meter apartments. There are 4 blocks, your lordship. And this apartment, your lordship, there's a 100 square meter apartment is meant for associate professor, and 200 square meter apartment is meant for professor, your lordship. And both 100 and 200 square meter apartment, your lordship, they're 3 BHK. The only thing is that the size is bigger, your lordship.
Okay.
Now, since the 4 blocks of this thing, 100 square meter apartments are already completed, ready, your lordship, till 200 square meter apartment is completed, your lordship, adjustment, the professor will be accommodated in the 100 square meter apartment, your lordship. That is what the inspection team has been informed, your lordship. So except for this, your lordship, except for this serial number 4, 200 square meter apartments, your lordship, the rest of the work, the progress of the work as given in the affidavit, which is filed by the respondent number 4, the Department of Health and Family Welfare, your lordship, they are correct, your lordship. Now, coming to next page, your lordship, page number 7, serial number 14. Serial number 14, your lordship has got it?
Yes.
This is equipment, library, books, journal, furniture, skill lab, computer, your lordship. Now, I am told that at the time of the inspection, we were informed that the order has been already placed. And this morning, I'm informed by the council representing respondent number 4 that consignment has already been placed, your lordship. So this is the status.
So what is stated in the affidavit is more or less correct.
Except for
Except for 7.
yes.
Lordship, I kindly see I've already supplied a copy of the letter that was written to the legal cell with regard to the equipments and the journals. As per the report, Lordship, in serial number 14, at the time of the visit, the consignment did not reach, Lordship. However, Lordship, by this letter, they have already received the journals. 95% of the journals have been received for the library, central library, and the other are in transit, which will be receiving by 25th April 2023. And the equipments for the Department of Physiology, Anatomy, and Biochemistry and other consignment are already in transit. Because at the time of visit of the team, we were informed that the consignment are on the way. Now, after the team visit, Lordship, it was last week, the NIMSER, the Nagaland Institute of Medical Science and Research, they have received the books, the journals, which will be used in the central library.
Okay.
And right after the visit of the inspection team, Lordship, the National Medical Commission inspection team has visited the site. And they have shown their appreciation, Lordship. Yes.
Yes,
Now the
counsel
only,
for the petitioner.
Yes, Your Lordship. Everything stated in the affidavit is accurate, Your Lordship. Now our concern
It
is
is,
that,
it is correct.
yes, it's accurate, Your Lordship. Now our concern is that the college has not obtained LOP, which is a letter of permission, Your Lordship. So if that could be expedited, Your Lordship.
Yes.
we are expecting the LOP, Lordship,
Okay.
with the progress, because it's phase-wise. We have to show our progress of the work, the requirements. So as far as the first LOP is concerned, Lordship, we have achieved the target. The buildings, the civil works, the books, the laboratory equipments, we have already received, Lordship. We are positive that we will be getting our LOP.
Okay. What was the other directions?
The sites.
Yes, learned additional agent.
Yes, the other direction is with regard to the HR, the manpower.
Yes.
The recruitment, the second phase, first round, second phase interview is conducted, Lordship, on 29 and 30 of March. And results have been declared. And the third phase, we are going to conduct the interview in the third week of April.
In regard to this 342 post of teaching and non-teaching technical staffs. Yes, Mr. MT, you were asked to give instructions as to what steps has been taken pursuant to the letter dated 3/3/2023.
Worship, regarding the teaching faculty, we are in the process of a war footing. And the government, we are keep on meeting every now and then. Even this week, there's another sitting regarding this interview and all. But the thing, the problem is that we could not proceed as we expected because in interview we advertised the post and applicant responded to the advertisement, but some are found not qualified. And again, there are some other problem. Then we are keep on postponing the interview date also in certain posts. So that is a problem we are going on, but we're in the process of war footing now. So
Mr. MT.
those are the steps taken by the
Mr.
state.
MT,
Yes, my lord.
can you kindly give all these letters in the form of an affidavit?
Sure,
It
sure.
would be very good,
Sure.
very kind of you.
Yes, I can do it.
So that para-wise, we want to know what you have done with regard to the
Well, Lord.
342
Well, Lord.
post. You please
Yeah, sure.
file an affidavit on this. And I hope you are aware about the order dated 15/3/2023 for creation of 342 posts. The department had written the letter. Can you have a look at the order dated 15/3/2023? 15/3/2023.
So your lordship, we are doing by the phase wise. First year, second year, third year. So we have already started phase one.
What is the affidavit dated on which this inspection was carried out?
Order dated 15/3/23.
What was that affidavit on which this order was passed? Okay. This is not the affidavit. Is that affidavit? 15?
Lordship, my affidavit is dated 14th of March. Basing on the affidavit filed by the respondent number 4.
Yes, wait, respondent number 4.
Yes, the affidavit is dated 14 March 2022.
Just wait.
Basing on this affidavit, the committee was constituted again.
This is 15-3.
Yes. The order is 15-3, Lordship, and the affidavit is 14.
Affidavit is 15-3.
I filed it on, it was signed on 14, but filed on 15, yes, morning. On 15 morning, it was filed, yes. And this is what this affidavit, you must execute it.
There's anything more?
Besides, Lordship, overall, as far as the development is going on, Lordship, now even the security has been placed
Okay.
for the campus. Police personnel from the Fort NAB have been deployed as a security as well.
Let us see. Mr. TV?
Lordship.
So 1, your affidavit.
Lordship.
1, 2, and 4.
Yes.
1, 2, and 4.
Lordship.
In the remark column,
Lordship.
the contractor has given the assurance that the entire work will be completed, will complete and hand over by May 2023.
Lordship.
So also with the serial number 2 same,
Lordship.
serial number 4 same.
Lordship.
So we tell the respondent government to file affidavit again on the progress of the work. Yes. On the progress of the work after 2 weeks. And Mr. MT, regarding all your this manpower appointment, kindly file an affidavit on this letter as well as in compliance to the order passed by this court. Okay,
Yes.
heard Mr. Heard MS so-and-so, the learned counsel for the petitioner, Mr. MT Imso, the learned additional AG, for the respondent, for the state respondent number, Mr. MT.
Respondent number 2, 3. Yeah, 2 and 3.
For the respondent number
2 and 3.
2 and 3. And Mr. Ann Mosri, The learned, Mr. Mojo, you are standing counsel?
No, Lordship, I'm engaged counsel.
The learned and engaged counsel for the respondent number?
4, 3, 3, 4. Lordship, the medical department will give us.
The engaged counsel for the medical department?
Yes.
Stop new para. By the order dated 15/3/2023. This code had constituted an independent committee to carry out the physical verification of the Medical College of Kohima. In order to verify the authenticity of the statements made by the state respondents in their affidavit with regard to the status report of the medical college building.
Lordship, instead of state government rule, but the affidavit was filed by the Department of Health and Family Welfare, right? Medical department, no.
It was on the basis of my affidavit, Lordship, to look into the veracity of
No, the affidavit was filed by the secretary. By the secretary.
Yes, signed by the secretary. Signed by the
Secretary.
secretary.
Stop. In terms of the order passed by this court, the team on 22/3/2023 visited the site for inspection. And on the basis of the physical inspection of the ongoing work, the progress / status no, not the progress status category. The committee has filed the affidavit showing the progress and the status of the work. We have perused the affidavit. And was also inquired from the learned counsel for the petitioner as to whether the progress/status of the work reflected in the affidavit is correct. And to which the learned counsel for the petitioner submits that the ongoing work of the medical college has been correctly incorporated in the affidavit by the independent committee. In para 5 of the affidavit, at serial number 1 and 2. Serial number 1, 2, and 4. The percentage of the work shown is 80%. And 70%. Stop. In the remark column, it is shown that the contractor has given the assurance that the entire work will complete and hand over by May 2023. Stop. In order to satisfy ourselves with the progress of the work, we direct the respondent number 3 and 4. We direct the respondent number 3 and 4 to file affidavit showing the progress of the work.
Lordship, 3 will do, Lordship. 4 is the mission director of
4 council,
3, principal director.
showing the progress of the work as showing the progress of the work in regard to serial number 1, 2, and 4 at paragraph 5
Lordship.
of the affidavit dated 27/3/2023, filed by the independent committee.
Lordship.
So, New para, okay. Independent committee. On,
Next date, Lordship.
yes.
After 2 weeks, Lordship.
Yes.
After 2 weeks would be on 26th. No, 26. It'll be third.
Let us list it on
3rd of May.
on 10th.
10th of May.
Let us give a longer period because
Fine.
actually,
Yes, Lordship.
okay,
Fine, Lordship.
on 10/5,
Lordship.
2023.
Yes, Lordship.
Insofar. No, not insofar, new paragraph. By the order dated 15/3/2023. The learned additional AG was also directed to take instructions as to what steps have been taken pursuant to the letter dated 3/3/2023, written by the department to the government for creation of 342 post. Today, when the matter is listed, the learned additional AG has placed the letter dated 28/3/2023, written by the Joint Secretary to the Government of Nagaland, Health and Family Welfare Department, to the Learned Additional Advocate General, Nagaland. Stop. The letter shows the update/action taken on PIL number 35 of 2017. Stop. We request the Learned Additional Advocate General to file proper affidavit on the compliance of the letter on the compliance of the order dated 15/3/2023 with regard to the creation of 342 posts of teaching and non-technical staff, as also the letter dated 28 March 2023, which is placed before us today. Stop. The affidavit shall be filed before the next date fixed. List the keys on. We have given 10th.
Yeah, 10th.
List the keys on. 10/5/2023. Okay.
Item 39,
Yes,
PIL
yes.
18/2020.
Yes, before that, I think we'll take it right now.
May I please, Your Lordship? Yes, sir.
Madam,
Yes, Your Lordship.
kindly give us 2 minutes break. Yes, ma'am.
Your Lordships, kindly allow me 2 weeks' time to file one additional affidavit.
Okay.
Recently, there's some new development, and then wherein the state respondents have already acknowledged and sanctioned some amount
Good.
to the INA freedom fighters and
Okay,
today's
okay.
cause.
MS Sangtila, the learned counsel for the petitioner, submits that she may be allowed 2 weeks' time to file additional affidavit in view of the new development in the case. Prayer is allowed, listed after 2 weeks.
Much obliged, Your Lordship.
Item 43 to 51, read April 16, 2022.
May I please, Lordship?
Yes,
My lord, this matter be heard together with item number 66.
what is item 60, what is this item?
Hearing item number 66. This is item number
Item
43.
66 is also listed today.
Yes, together.
So what is this item?
This one is 43 to 51.
For the,
41 to 43.
no, what is the matter about?
Oh, this is work charge regularization.
Work charge regularization.
Yes, ma'am.
Let us see whether we can have that time.
Yes.
Okay, listed with item number 66.
Item 52, read Appeal 35, 2022.
Your Lordship, even this one also, I have the similar prayer, Your Lordship.
With item?
66.
Oh, is it?
Yes, 66 should be the lead-in case. Your
Lead
Lord-
case?
Yes, yes.
Okay. Okay, let's just with item 66.
Item 53, read Appeal 36, 2022.
Lordship, this case, this is an appeal against the judgment passed by the learned single judge directing the respondent to pay the minimum scale of pay. Then Your Lordship has already passed a judgment dismissing the stake appeal. So Lordship, I may be allowed to produce the judgment.
Miss Sokre, see, regarding equal pay for equal work, the facts may be different in various cases.
Lordship,
So just because this court, the division bench has passed one order in view of the facts and circumstances in that case, directing the state to pay equal pay for equal work done,
Lordship,
doesn't mean that that case should cover all the other cases where actually similar claim is made.
the,
We have to see on the facts and the circumstances.
the principle that was decided.
No,
by this- yes.
principle would depend on the facts and circumstances, not just blindly like.
Yes, but even in the single judge also, Your Lordship, the single judge relied upon the judgment passed by the Supreme Court, Judge Jackson case. And he
No,
has.
that's
given
why,
yes.
that's why reliance on the Supreme Court, Judge Singh case is the lead case. But I think every case will have a different fact. Every case will have a different case. In some cases, actually, the petitioner may not have actually satisfied the court.
Lordship,
But in some cases, the petitioner may have satisfied the court that they perform equal work by actually bringing all the datas before the court. So I think just because even the Supreme Court also, in some cases, equal pay for equal work was granted. In some other cases, by citing various other grounds, by citing various other reasons, it was not granted. So it would depend on the facts and circumstances of the case. So just because the division bench of this court has decided a case in favor of equal pay in a particular case, doesn't mean that that case should automatically apply to all the cases. I think that is what.
Lordship, in my view, is that more or less this case and one which was dismissed
So
by the division bench. Yes.
We will have to see the facts and the
Lordship,
circumstances. We
Lordship,
will have
if
to
that
see.
is the case.
Yes, that's why I was always insisting equal pay for equal work. It is not automatic.
Then Lordship, in that case, the matter may be fixed some other date, Your Lordship.
So if that is the case, then we have to fix that 66 and Mr. Tiba.
Lordship, this is for minimum scale of pay. The others are for work charge regularization.
Okay,
Yes,
okay.
yes.
Okay. So this is for
Item 53 to 57.
okay.
These are for minimum scale of pay.
Let you also see. Let the court also examine whether
Otherwise, in my view, this has been covered by
the
division
order
bench.
passed by the Supreme Court or the order passed by the division bench of this court will also cover this case in view of similarity of the facts and circumstances. Okay, let us also examine that aspect. Not just blindly we say that because in a particular case that relief has been granted. So also in this case, since the prayer is for that, we should grant. When can we fix it?
After 2 weeks, Your Lordship.
Okay. On the prayer of the Lenient Council for the parties, listed after 2 weeks.
Much obliged.
Obliged, Lordship.
Where is-
Item 54, read Appeal 37, 2022.
Lordship, 53 to 57. Yes.
This order,
Yes,
equal pay for equal
Yes,
work.
yes, Lordship.
Item 58, read Appeal 3, 2023.
Lordship, here, the stake, we are challenging the challenging Your Lordship, the single judge judgment dated 4/11/2020, directing the AG to pay the second financial upgradation to the petitioner, Lordship.
By counting ad hoc service.
Yes, by counting the ad hoc service, Your Lordship. So, Lordship,
Whether this financial upgradation
yes,
under the MSCP scheme
yes.
is to be paid for ad hoc service.
No, no, Lordship, because it's very clear, Your Lordship. Here, the finance department, Your Lordship, may come to page 102. Earlier, it was ACP, and after that, it was modified. as
modified.
Yes, yes, MSCP. Page 102, Your Lordship.
102 is.
Yes. Point 1. It is found that in many cases, the period of contract service is counted towards all service, pay, benefit like pension, leave pay, etc., except seniority as per condition given at the time of regularization of the services. In such cases, whether such contract service should be counted as qualifying service for financial upgradation under MSCP scheme. So the clarification given by the finance is the MSCP scheme does not cover the employees appointed on contract ad hoc overcharge basis. If any of this category of employees are subsequently regularized and the past continuous service on contract ad hoc overcharge basis are allowed to be counted for pensionary and other service benefits, still the seniority in service is counted from the date of regularization only. In view of this, for allowing the benefits under MACP scheme, The qualifying length of service shall be counted with effect from the date of regularization only. The period of service rendered on ad hoc contract or work charge basis prior to regularization will not be taken into account for computation of length of service for grant of benefits under MACP scheme. So, Your Lordship, it's very clear.
Yes, with the period of service rendered on adult
Or
will
work charge
not be
base-
taken
yes.
into.
Because Lordship here, the petitioner, he was initially appointed as a graduate teacher on ad hoc basis, and thereafter his service was regularized. Yes, so the SCP scheme of 2002, that was not made applicable to the graduate teacher because the graduate teacher are enjoying higher skill pay. Only in the year 2008, the SCP scheme was made extendable to the graduate teacher. So accordingly, the petitioner was granted SCP with effect from 21 to 2008, Your Lordship. Yes. So if we counted the first SCP from 2008, his second cliff should be in the year 2018.
That is after a gap of
A gap
12
of 10
years.
years. 10 years, Your Lordship. Yes. After a gap of 10
So
years.
2002, the MSCP was effective from
21 to 2008.
21 to 2008.
Yes.
So 21 to 2018.
should
That is
be-
the first MSCP.
The first MSCP is 21 to 2008. The SCP is 21
So it
to
was also extended with effect from 21 to 2008.
2008. Yes.
And the second benefit will be
21
effective from 21 to 2018.
Yes, Lordship.
Ah.
Yes. However, the learned single judge, he counted his ad hoc period, the initial appointment of the petitioner to be treated as his regularization,
Okay.
and directed the EG to pay the second financial upgradation from 1/4/2012, with effect from 1/4/2012.
So 1/4.
2012.
That is the first or the second?
That is the length of service counted by the learned single judge.
He was regularized with effect from?
With effect from Lordship, with effect from 14/5/2001.
14/5/2001.
2001. Yes. So he got his first financial upgradation on 21/2/2008.
21 to
2008.
that is the date of enforcement of the
Yes.
government notification.
Yes, to the graduate teachers.
Okay.
Yes.
So the first one, the first is on 21 to 2008.
Yes.
And the second will be on 21 to
2018.
2018.
Yes.
What was the direction given by the learned
The
single judge?
direction wants to pay a second financial upgradation with effect from 1/4/2012.
Second financial upgradation
Yes.
from
1/4/2012.
1/4/2012.
Yes. So if we take this second single judge judgment to be correct, then there will be a gap of only 6 years to be entitled for second financial upgradation.
No, what is the basis of the learned single judge taking this 1/4/2012?
Lordship, I may be allowed to take you to the learned single judge. Lordship may come to page 273. 273. This is the learned single judge.
273.
Yes. Para 25.
Two 273.
Yes, I may be allowed to read para 25. The submission of the Learned Counsel for the respondent also vividly clarifies that the employees are entitled to the third leave on completion of 30 years of service. In reply to the allegation by the petitioner that those teachers who have served only for 4 to 5 years of service in 2015-16 received third leave, it was replied that it was concerning those employees who have completed 30 years of service. By the reading of the OM dated 10/3/2011 at column 3 and the clarification of the Learned Counsel for the state respondent, it is discernible that third leave is accorded to employees on completion of 30 years of service. The same has been adopted by the state respondent as such. Thus, from the reading of the various office memorandum by the state respondents, it can be concluded that all cases which were settled under the SCP cannot be reopened as per OM dated 12/10/2010. Hence, granting of first leave under SCP by 1/4/2002 by the strength of circular dated 28/7/2004 cannot be reopened now. Number 2, by this analogy, the operation of OM dated 10/3/2011, the petitioner is entitled to second leave on 1/4/2012.
1/4/2012.
Yes. The grant of second leave on 23/4/2010 is therefore inappropriate as per the state respondent's notification. Therefore, the emoluments drawn between 1/4/2010 and 1/4/2012 are refundable to the respondent. Number 3, the petitioner is entitled to third leave on completion of 30 years of service as per the OM dated 10/3/2011 and as per the clarification of the Learned Counsel for the state respondent. Thus, without the infringement of the order dated 25/2016 and OM dated 26/8/2011, the correct interpretation of the OM and circulars and orders of the state respondent, the rights of the petitioner is conceivable to the extent indicated above. It may also be added here that Sunita Chakraborty case and Naban Potima case are supportive of the petitioner case. The respondent number 5 is directed. This respondent number 5 is the AG, Your Lordship. Is directed to prepare the pay of petitioner by granting second financial upgradation with effect from 1/4/2012 and to pay the petitioner all the benefits therefore after deduction of the excess drawal with effect from 2010 to 2012. It is also made clear that the petitioner shall be entitled to the benefit as contained upon OM dated 10/3/2011 and the para 3 as adopted by the state respondent. If Your Lordship come to page 24, page 20, not 24, no. My apology, Your Lordship, it's not page 24. Lordship may come to page 264. 264. Page 264, para 15. If we, para 15, 10th line from the top. Para 15, 10th line from the top. Hence, this court, Lordship, hence this court, has Your Lordship got it? Yes. Hence, this court is of the view that 16/4/1990 will be treated as the date of regular appointment for all purpose of computation of the salary and wages of the petitioner in terms of circular dated 28/7, which remain unaltered. This is how the learned single came to a finding that his initial appointment on ad hoc basis, that is 16/4/1990, to be treated as his regular appointment, Your Lordship. So there is a perversity in the order.
Okay, we'll hear you. Let us come chronologically, okay?
Yes, Your Lordship.
If not, we will discriminate the others.
Yes. So, Your Lordship, my prayer is that I have applied for a stay. So, Your Lordship,
Your Lordship, no stay may be granted. The matter may be, it is a very simple case, Your Lordship.
or we can take
The
up
facts
in the
which she has
after,
submitted, I would like to clarify that.
in the second half, Your Lordship, we can take up
Yes.
so, because it's a simple, Your Lordship, whether the petitioner is entitled for a second upliftment with effect from 1/4/2012 or not. That is the issue, Your Lordship. Yes. So
Okay,
it's
let's see whether the time permits.
Yes.
We'll come
Act 2,
chronologically.
Your Lordship.
Yes, Your
We'll
Lordship.
come chronologically.
Lordship.
Yes,
I will.
we'll continue, yes.
Yes, next.
Item 59 to 60. Civil Division 5, 2020.
59 to
Your
60.
Lordship, these matters have been transferred back from the principal seat.
Yes.
And since the matters are ready for hearing, if the matters may be posted for admission hearing after 2 weeks.
What? Mr. Fuseko,
Yes, Lordship.
who are the parties? Let us first see, since this is a transferred matter.
State, yes, state. So they-
State.
Yes, state is also.
Lordship, this is Mao Im-chen's matter.
This is a transferred
Yes,
matter.
yes.
Mr. Fuseko, you are for?
I'm for the petitioner in Civil Revision 5 of 2020.
Civil revision.
5 of 2020.
So civil revision and you are for?
I'm
Respondent.
for the petitioner in Civil Division 6
Where is this?
of 2021.
Item number 6.
Okay, in 5. Who is for respondent number 4 and 5? In 5. One to three is the government.
Respondent 4 is the complainant. The
Respondent number 4 is Mr. Sebastian.
Sebastian, and
And 5 is
the
Solima Village Council.
Lordship.
So who is representing them?
Lordship, they were represented.
They were being represented. Yes.
Is this the first time after transfer?
Yes, yes.
Then?
Yes, Lordship. Their names are not reflected, but they're represented.
No, they were represented in the principal seat.
Yes, Lordship.
Not
Yes.
here.
In fact, before transfer also they were represented.
No, whether they have the knowledge that the case has been transferred?
Yes,
Yes, they were there in the principal scene also.
Here,
yes,
in Kohima bench?
yes, Lordship. Lordship, in the judgment of the single bench, Lordship, they represented, Lordship. Represented by Miss
No,
K.
no, before this bench, before now the division bench.
Yes, Lordship. In fact, this is the first time listed after transfer from Gauhati. From the principal bench.
That's why I am actually on that. Who is for the petitioner in 5?
Lordship, I'm the petitioner
In 5.
in 5, Civil Division 5.
So why don't you take steps upon 4 and 5?
No, Lordship, please, Lordship. Lordship, there was a letter sent out by the registry, and the letter was handed to them. They have received that letter. The letter was dated 3/2/2023 regarding transfer. So they have received that. Or Lordship, I'll communicate to them verbally. Instead of sending notice, they'd be prolonging the matter, Lordship. I can inform them telephonically.
They may deny your information.
Lordship, but
They were there also before the principal seat.
And they are aware.
Principal seat, okay, we know, but whether they have been represented here. And if it is the first time, is it not incumbent on this court to issue notice?
Latest dated 3/2/2023.
By which order the matter was transferred?
By order dated 23rd January 2023.
Oh. You take steps for notice, okay?
Lordship.
Mr. Fuseko? The learned counsel for the petitioner? In civil revision number 5, civil revision
Yes. 5 of 2020.
5 of 2020. And you are for the petitioner in civil revision 6?
6 of 2021.
And Mr. Iralu, the learned counsel for the petitioner in civil revision petition number 6 of
2021.
2021. By the order dated 23/1/2023, passed by the Honorable Division Bench at the principal seat of this court. Both the petitions were transferred to the Gauhati High Court Kohima bench. Stop. The matter has come up for the first time after the transfer. Stop. Mr. Fuseko, the learned counsel for the petitioner. Whether 6 notices required, 6 also.
6. My learned friend is appearing for the private respondent and
For
for
the
the state
two.
respondent is represented.
Okay. And respondent number 4 and 5 in in this civil revision
Revision 5.
petition. 5. They are another party in 6.
No, no.
No, Lordship.
Oh, they are another party in 6. Okay.
In fact, there are 2 different matters, but
Okay.
the low point.
What was the
is-
last line, madam? Yeah. Mr. Fuseko, Mr. Fuseko, the learned counsel for the petitioner shall take steps for service of notice upon the respondent number 4 and 5 by registered post with AD within a period of
3 days, Lordship.
within 3 days from today. Listed after 2 weeks.
Yes, my Lord.
Item 61, I am criminal 19/2023.
May it please your lordships.
Yes.
My lord, as per the office note dated 7/2/23, service of notice served upon respondent number 2 is still awaited. Therefore, let this matter be listed after 2 weeks, my lord.
Where is that office note? As per the office note dated 27/3/2023. Return service reports on respondent number 2 is still awaited. Awaiting the service report listed after 2 weeks.
Much obliged.
Then we continue.
Lordship, item numbers, hearing item 66 to 72, Your Lordship, this is an analogous matter. And today will be the last day Your Lordships will be sitting, and
Yes.
very unlikely it may take time, Your Lordship. So if the matter will be adjourned for the day, Your Lordship, 66 to 72 is a hearing matter.
66
To
to
72, Your Lordship.
72. Okay.
So after 2 weeks.
Item 66 to 72.
72,
Okay.
Your Lordship.
On the prayer of the learned counsel for the parties, list the case up to 2 weeks.
Much obliged, Lordship.
Yes, continue. We will continue. We'll continue.
My lord.
No break.
May I please, Your Lordship?
Yes.
By an order dated 1/2/2023 of this honorable court, I was allowed to take steps upon the respondent number 5.
By which order?
Order dated 1/2/2023. I have duly taken the steps through registered posts.
Ah.
So if not, I may be allowed to take fresh steps upon the respondent number 5, Your Lordship, again.
You have taken steps as per the order dated 1/2/2023.
Yes, Your Lordship. I have taken steps in compliance of this order, but it seems they have not appeared. So I may be allowed to take fresh steps, Your Lordship, through registered post.
There is nobody for respondent number 5.
Yes, Your Lordship.
No. Even before the learned single judge, it was not represented. But if the petitioners insist on serving notice, then
Okay, we give them one more chance. Okay. By the order dated 1/2/2023, appellant was directed to take steps for service of notice on respondent number 5 by registered post with AD. Stop. Today, when the matter is listed, the learned counsel for the appellant submits that the order dated 1/2/2023 has been complied with by issuing notice upon the respondent number 5. Stop. There is, however, no representation on behalf of respondent number 5. The learned counsel for the appellant submits that he may be allowed to take fresh steps upon respondent number 5 by registered post with AD
Yes, Your Lordship.
within
2 days, Your Lordship.
within 2 days from today. Stop. Prayer is allowed. The learned counsel for the appellant shall take steps for service of notice upon respondent number 5 by registered post with AD within a period of 2 days from today and file affidavit to that effect. Listed after 2 weeks.
Your 3 weeks, Your Lordship.
Listed after 3 weeks. Okay.
Much obliged.
Item 63. IS 6.
May I please, Your Lordship?
Yes, please.
I beg to mention item number 43 to 52. This matter we kindly listed along with
We have actually observed that this matter will come up with 66.
Yes,
Can you
yes.
wait for some time?
Yes. Since item
Oh.
number 66 has been already adjourned, Madam.
Adjourned.
So matter be listed along with this item number 66.
Which item?
This item number 43 to 52.
Item 43 to 52. You are the counsel for the
Appellant.
on the prayer of the learned counsel for the parties. List this case along with Read Appeal 26
Yes, my lord.
of 2022.
2022.
Okay.
Much obliged.
May I please, Lordship?
Yes.
My lord, I have instructions to withdraw this appeal, my lord. As such, I may be allowed to withdraw the writ appeal along with the connected
Ali, what is
IS.
this? IS6?
I is for continuation of delay,
Okay. Okay.
and then the IA7 is for stay.
So what do we do? Read appeal, your delay is yet to be condoned.
Yes, it's yet to be condoned.
So how this read appeal was registered and how this application for stay was also registered?
So, my lord, if the IA may be allowed to be withdrawn,
The rest follows.
yes.
See. Please tell the registry that will never go into competition with the total registered machines. Because actually only after condoning, we will give a direction. Please stay connected. Mr. N. Longkumar, the learned counsel for the applicant, submits that he has instructions to withdraw the application. Stop. The application is accordingly disposed as withdrawn. Over. There was one software and all this.
66 was the leading case.
Okay.
Lordship, 50 item 58, Your Lordship, I think is still there.
58, let's see. 58. Yes, what is this?
Lordship, that MSCP case that that Chokre was submitting, Your Lordship.
Whether this is that is not admitted still.
Lordship,
Lordship, it has not been admitted. Only on the last occasion, delay was condoned, Your Lordship.
Then we'll admit it and list it for hearing.
Lordship, yes, but Lordship, stay may be granted because Your Lordship.
Next day, next week.
If that is the case, then Your Lordship, I'll make it open so that we can dispose the matter on the, because there are two writ petitions still pending before the.
Make it open in
single
a
judge.
sense, ma'am.
Our Lordship, not fixed in the hearing list, but in the admission so that on the next date fixed, we can take up the matter, Your Lordship. Otherwise, Your Lordship.
We'll admit the appeal and we'll list it on 19th.
Lordship, on 19, I have a difficulty.
If not before that, because tomorrow me and my lord,
Yes, yes.
we may be leaving for Gauhati.
Yes, yes. Lordship, my prayer is that a stay may be granted because if Your Lordship.
No. We will hear properly. And whether to grant stay or whether to hear.
Lordship, then in that case, on the issue of a stay, that may be heard today, Your Lordship, because there are two writ petitions still pending, Your Lordship.
If you are not paying, there is no urgency. Whether actually the discretion whether to pay or not lies on you. You are not paying, I know.
Your Lordship, for that matter, we have filed an appeal, Your Lordship.
That's why.
Yes,
that's
yes.
why you have filed an appeal.
Yes.
So since the appeal is there, maybe I think the other side will also not just blindly insist.
Your Lordship.
So you can take up next week. We'll fix it next week.
Lordship,
Appeal,
not next
appeal
week.
admitted.
Oh, Lordship, after 2 weeks, Your Lordship, in that case.
Appeal admitted. Listed after a
2
week.
weeks.
Let's see. You can take chance.
Lordship, next Wednesday, I won't be here, Your Lordship.
Listed after.
Yes, 2 weeks.
Listed after 2 weeks. Okay.
Okay, much obliged.